case briefs, and so much more. LSData's got what you're looking for.
The United States Court of Appeals for the Seventh Circuit ruled on the case of DF Activities Corp v. Brown in 1988, shaping the understanding of the statute of frauds in relation to contracts for the sale of goods exceeding $500. According to UCC Section 201(3)(b), although oral contracts are generally enforceable, the clause stipulates this only applies if the party in question admits in court or other legal proceedings that a contract for sale was indeed established. In an intriguing turn of events, the Dominos owner and Plaintiff DF alleged that they had entered into a verbal agreement with the defendant, Mrs. Brown, for the purchase of a Frank Lloyd Wright-designed chair at the cost of $60,000. Upon sending the first check and a confirmation to Brown, she rejected the payment after a fortnight, citing the discovery of another potential buyer due to the delayed feedback from DF. In response, DF initiated a lawsuit against Brown, only for the case to be dismissed by the district court. Unsatisfied with the ruling, DF appealed, contending that they should have been accorded the opportunity to depose Brown in hopes of unveiling her admission of the contested oral contract. Despite DF's appeal, the dismissal by the district court was upheld by the appellate court. The court reasoned that additional discovery was unlikely to result in Brown perjuring herself by negating her initial refusal of the oral agreement, thereby rendering the provision of UCC Section 201(3)(b) inapplicable. Thus, the case underscored the necessity of obtaining required signatures promptly in contract deals and served as a significant precedent in the interpretation and application of the UCC statute of frauds.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.